Welcome to Legal Studies, and today we're going to be learning about the relationship between courts and Parliament. So how do they interact with each other? Where are we in the study design? Here we are down here. Now it looks like a big dot point, but it's all fairly straightforward, and we're going to learn it in just this one video. There are 5 different ways that courts and Parliament sort of interact with each other, 5 different relationships that they have with each other. So what do you need to know? Well, you need to be able to define what each of these are and provide examples. So our first of our 5 relationships between court and Parliament is the idea of the supremacy of Parliament. And what that basically means is that we say that Parliament is the supreme lawmaker. So typically any laws that Parliament creates sort of overrides what court is doing. And some examples of the supremacy of Parliament, some examples of the idea that sort of Parliament is more important than the courts when it comes to lawmaking, is the idea that Parliament actually creates the courts for the most part. They decide what types of cases the courts hear, and they create the laws that the courts look at. So, for example, an example of Parliament creating the courts, the Magistrates Court recently had a new division created as part of it, a new aspect of the Magistrates Court called the Drug Court, where they specialised in hearing about drug crimes and used a more therapeutic approach to helping people. So Parliament creates the courts. Parliament also can set limits on how the courts operate. So, for example, they can change the minimum or maximum sentences for particular crimes. So this is all boiling back down to the idea that Parliament is the supreme lawmaker. Parliament is, the more important lawmaking body, and court sort of helps in a more supplemental role. So that's our first relationship. Our second relationship is that, well, if Parliament makes the law, then court's job is to interpret the law. And we've already learned about this before. Statutory interpretation is one of the main jobs of courts. And our example of this is, well, we have lots of examples that we can draw on, but the studded belt case is a good example of this. And that's a case in which a young man was arrested for wearing, one of those punk rock studded belts. He was brought to court by the police and charged with possessing a weapon. And the courts had to interpret that law and say, well, what is a weapon? Actually, we don't think this is a weapon, and we think it's an article of clothing. So Parliament makes the law, and courts interpret it. That's one aspect of their relationship. Another aspect of their relationship is, well, once courts make a decision, that can influence Parliament. Right? Whenever courts make a decision, set a precedent, Parliament will look at that and they'll have to decide essentially whether or not Parliament agrees with it or disagrees with it. So anytime the courts make a decision, Parliament is influenced one way or the other. Perhaps Parliament might agree and say, all right, well, yeah, we like that law. Well, they might decide to get rid of that law. They might change it. And this leads us to our final 2 relationships. Once the court's decisions have influenced Parliament, Parliament can choose to either codify the law that court made or abrogate it. And so essentially what this means is codification is when Parliament chooses to accept the law that courts have made and turn it into a piece of statute, turn it into a law that Parliament makes. So, for example, our example here is the Mabo case. So in the Mabo decision, the court decided that Australia was not terra nullius. The court decided that Indigenous people had an ownership and connection to the land of Australia. Parliament then looked at that precedent that the courts had made and turned it into a piece of legislation called the Native Title Act. And essentially that piece of legislation codified or wrote down formally the processes and ways by which Indigenous people could make claims over ownership of land and things like that. So codification is when Parliament looks at a precedent set by court and says, oh, we really like that. Here, let's write it down properly and turn it into a statute, so it's easy to read. Abrogation is the opposite of that. That's when Parliament doesn't really like the decision made by courts and decides to overturn it and make their own law that does it differently. So here, our example of that is something that we've looked at in the past already. Trigwell is our example of that happening. In the Trigwell case, courts basically were looking at a possible negligence case. You know, a farmer's sheep had wandered onto the road and caused a car accident, and somebody had died. And you know, the farmer was being sued for negligence, and basically the court said, well, precedent says that, you know, this farmer's actually not responsible for their sheep. We don't think it's a particularly good precedent, but we're not going to change it because we think Parliament's in a better place to make some sort of change in this area. And so court kept this old and outdated precedent. They decided to keep it around, and so Parliament looked at that and said, all right, we're going to overturn this. We're going to write a law that changes everything up, and we're going to write down a law that makes clear what the law of negligence is. And they created the Wrongs Act. So they sort of overturned what had happened in the Trigwell case. And this is called abrogation. And those are our 5 relationships between court and Parliament. First, we've got the supremacy of Parliament. They sort of create the laws, they create the courts, and in turn, the courts then interpret the laws made by Parliament, and this can influence Parliament to either codify, accept those laws, or abrogate, overturn them. And that's our relationship between court and Parliament. See you next time.